If you're watching this video, it's because you're curious about probate. That's a word that is greatly misunderstood and at times even intimidating to some people. All probate really means is an application to the probate court to recognize the validity of a document that is your will. It is not always necessary to apply for letters probate of that will, which is the document which acknowledges and confirms the validity of the will and the appointment of the person named in it to administer your estate. It's a popular misconception that probate is necessary for only large estates. It is often the case that even modest estates, because of the nature of the assets, require probate because the person or the institution, such as a bank or an insurance company, which has possession of the assets, will not turn them over or deliver them to your administrator or executor or executrix unless they have obtained letters probate. The reason for that is simple. Insurance companies, financial institutions are not unaware that when persons make more than one will, it is the last will and testament that is considered the valid document. Without probate, financial institutions, insurance companies, and other interested persons who are the custodians of assets may not feel comfortable turning those assets over to the named individual in a document that is not probated. The concern is if later on a newer, more recent will emerges and it names a different person, they may have liability for having turned over the assets to the prior named person. It is often necessary for the administrator, executor, or executrix to obtain letters probate in order to be able to effectively deal with assets. If you're wondering about the distinction between the terms administrator or executor or executrix, an administrator is a person who is appointed by the court when you have no will that names a person to administer your estate, and an executor or executrix is the person that we refer to that you've named in your will to be the person that you want to administer your estate. Probate fees in New Brunswick are very modest. For estates less than $25,000 in value, the fee to obtain letters probate is very nominal. For estates in excess of $25,000, the probate fees are based on $5 per thousand of value. In other words, a $100,000 estate attracts a $500 probate fee at the time of applying for letters probate. It is not a significant cost for your estate to bear, and attempts to arrange the ownership of assets prior to death, such as jointly re-registering property, such as a house and land in the name of the individual along with an adult child or children, may have the unfortunate added complication that in their dotage, if the person requires the return of their property, this may create legal complications in obtaining the return of the property to the parent.